May it please your Lordship. Lordship, I seek your Lordship's indulgence in making mention of item 9 of part 2, hearing list. Lordship, since the conducting counsel, Mr. Sridhar Ramzawa, could not appear today due to some personal difficulty, if this matter may be taken up next week.
Item 9.
Yes,
You are for the petitioner.
yes, I'm appearing on behalf
Have
of
you
the
informed the
Yes.
counsel for the other side?
Yes, consent have been taken.
Okay. Mr.
Stephen Lalbuatsaya.
Learned counsel submits that the learned counsel for the conducting counsel has some personal difficulties today, therefore seek adjournment for the day. He has also obtained consent from the learned counsel for the respondent in view of the above, and as prayed for by the learned counsel for the petitioner. List this matter after
If this matter may be listed on next week,
next week.
yes.
Okay. And is prayed for by the learned counsel for the petition. List this matter next week. Okay.
Oblige.
May I seek your Lordship indulgence in mentioning part 2, item number 7, Lordship. I'm appearing on behalf of the Legal Aid Council.
Okay.
Yes, Lordship. If the matter can be kindly taken up after 2 weeks, consent has been taken, Lordship.
Okay. Miss,
No, Ropari.
your legal aid counsel,
No, Lordship. On behalf of the Legal Aid
Okay.
Council.
learned counsel appearing on behalf of Mr. T. Lal Zakima, learned legal aid counsel for the petitioner, with the consent of the learned counsel for the respondent, prays for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks.
Deeply obliged.
Your Lordship, I seek indulgence in mentioning part 2, item number 2.
Item
Number 2. Since the main counsel is on leave, can the matter be listed on 30th of this March?
to be
We
listed
have-
on
30th, 30.
30.
Yes. I have taken the consent from both the parties.
Okay. Let me know. Miss,
Tien Sang Pui.
learned counsel for the learned counsel appearing on behalf of the petitioner with the consent of the learned counsel for the respondent, prays for listing this matter on 30th
Yes.
March.
Sure. Yes, sir.
The prayer is allowed. Listed accordingly on 30th March. Okay.
Yes.
For motion, item number 1.
Lordship, this petition is filed praying to invoke the supervisory jurisdiction of this honorable court
Just a minute.
under 227.
Just a minute. This is item 1.
Item 1, Lordship.
Okay. Yes.
Lordship, the Honorable Additional District and Judge, District Session Judge, in his judgment and order, dismissed the application filed by the present petitioner, Lordship. And the relevant para is at page number 51, Lordship. May I kindly take you at page number 51. Para 10, Lordship.
Okay. Additional district judge.
Additional District Judge, Lordship.
Okay. Para 51.
Para, sorry, page number 51.
Page 51. Para 10.
Para 10, Lordship.
Okay.
The last sentence. Anyway, Lordship, I'm coming from Para 10. I'm coming from Para 10. Yes.
Para?
Para 10, Lordship. Para 10. Page number 51.
Yes.
As the course title of, I'm reading, Lordship. As the course title of the present suit itself states, Civil Miscellaneous Application number 453 of 2025, arising out of miscellaneous arbitration case number 47 of 2005, and interlocutory case number 369 of 2015. And the subject matter of the present application had already been issued before the 3 members arbitral tribunal between the parties, and the order judgment of the arbitral tribunal was appealed before the district judge. The Honorable High Court and the Honorable Supreme Court, I'm stressing here, Lordship, I do not have power to reconsider the subject matter, invoking the inherent power of the court. Supposing the present application is not covered by the decision of the arbitral tribunal, the district judge, the Honorable High Court and the Honorable Supreme Court, as mentioned in the above provision of the Mizoram Civil Codes Act 2005. This court does not have pecuniary jurisdiction to entertain the application case. Therefore, the instant application stands dismissed. The meaning that, Your Lordship, this case, in fact, is a contractual agreement between the petitioner and the respondent, Your Lordship. And there was some problem between them, resulting the case put up before the tribunal, constituted under Arbitration and Conciliation Act 1996. And thereafter, the matter comes before the High Court and then the Supreme Court, Lordship. And thereafter, for maybe the third or fourth round, it comes before the Additional District Session Judge, Your Lordship. And before the Additional District Session Judge, Your Lordship, the petitioner approached the court under the CPC 151, Lordship, by trying to invoke the inherent jurisdiction, Your Lordship, for release of the bank guarantee amounting to rupees 10 crore something, Lordship.
So that was not decided by the district judge, the High Court and the Supreme Court and the arbitration tribunal.
In our interpretation, in our view, Your Lordship, that's not decided, Your Lordship. That's left aside, Your Lordship.
No, which was decided by those court then?
Lordship, that rupees 10 crore, in fact,
10
was,
crore, this 10 crore was not the subject matter of the
yes, in
petition
our
before.
view, Your Lordship, that is
in the
matter.
arbitration also?
Lordship,
Before
in
the
our view, Your Lordship.
Okay, then
Then trying
It was-
to invoke 151 of CPC, Your Lordship, we approached the Additional District and Session Judge, Your Lordship. And the Additional District and Session Judge thereafter dismissed our application, Your Lordship. So, Your Lordship, by this petition, as of now, Your Lordship, we are trying to pray this Honorable Court to look into the matter as to whether this impugned judgment and impugned order is sound or not, Your Lordship. For that, Your Lordship, this petition is filed before this Honorable
now
Court, Your
see,
Lordship.
after the district judge decided, the arbitral tribunal decided, the High Court and the Supreme Court,
Lordship.
I think the matter has reached the finality, attained the finality. And how this additional district and session judge would be able to take up the matter again, over and again?
Lordship, for that, Your Lordship, to make it clear, it may be better for me to read out the submissions made before the Additional District and Session Judge, Your Lordship.
No,
That is at page number 45, Your Lordship.
Submission is different. Now, let us come to the fact, whether it was not a subject matter. It was subject matter before those court,
Actually,
before
Your
those
Lordship,
tribunal also.
it was a part of subject matter.
Then,
It was a part of subject matter, but, Your Lordship, the original case, in fact, was much more than rupees 10 crore, Your Lordship. But there was a cancellation of bank guarantee, encashment of bank guarantee amounting to rupees 10 lakhs, Your Lordship, rupees 10 crores, Your Lordship. So that matter, in fact, was not the subject matter before the Supreme Court and the High Court, Your Lordship. So that, Your Lordship, that was the matter which put up before the Additional District and Session Judge, Your Lordship. To make it clear, Your Lordship, may I read out the submissions rendered before the Additional District and Session Judge, Your Lordship. Page number 2 of, para 2 of the order, Your Lordship.
see, submission, you will make submission
Page number
here
45,
also.
Your Lordship.
Page?
Page 45. Page 45.
We need to see the observation. Submission, here also you will make so many submission. But then we need to see the observation.
The observation, Your Lordship. Yes. For page number 49. Page number 49, Lordship. Para 4.
Yes.
Heard both the counsels peruse the record, it is an admitted fact that the terms of contract included an arbitration clause. An arbitration proceeding had been invoked, the decision of which was appealed before the learned district judge, right order date 30/4/2013, passed in arbitration case number 30 of 2011, and the district judge was pleased to dismiss the objections filed by the applicant under section 34 of the Act, that being aggrieved by and dissatisfied with the aforesaid order dated 30/4/2013, the applicant preferred a statutory appeal under section 37 of the Arbitration and Conciliation Act 1996. challenging the said dismissal, and the Honorable High Court was pleased to dismiss the appeal filed by the applicant by judgment and order date 29/5/2024, passed in arbitration application number 1 of 2013. That being aggrieved by the judgment and order date 29/5/2024, passed by the Honorable High Court in arbitration application number 1 of 2013. The applicant preferred a special leave petition before the Honorable Supreme Court of India. However, the Honorable Supreme Court, via its order date 6/9/2024, was not pleased to grant leave to appeal and accordingly declined to admit the special leave petition before hearing, thereby endorsing the order passed by the Honorable High Court in the appeal under Section 37 of the Arbitration and Conciliation Act 1996. It is also admitted fact that the applicant had approached this court under Section 151 of the Code of
No,
Civil.
from the para 4, what more survives, Land Council? It appears all, I think, the provisions have been exhausted.
Lordship,
All available provisions, it appears, have been exhausted. Then, what more survives according to you?
Lordship, in my submissions, the rupees 10 crore, in fact, was left
That was
untouched.
decided, that was decided,
That's
that
not-
you submitted.
Lord, in my submission, that's not decided, Lordship. In my submissions, Lordship.
But you
So-
said that earlier in the arbitration also, so this was a subject matter and decided.
Lordship, may I continue, Lordship? Para 5, Your Lordship.
Para 5.
Yes. It is also admitted fact that the applicant had approached this court under Section 151 of the CPC, invoking the inherent power of this court. Section 151 CPC reads, saving of inherent powers of this court, nothing in this court shall be deemed to limit or otherwise affects the inherent power of the court to make such order as may be necessary for the ends of justice to prevent the abuse of the process of court.
That is true, but
Yes.
this matter went up to Supreme Court.
Lordship. But, Your Lordship, in that Supreme Court, the matter was much more than rupees 10 crore, Your Lordship.
So that includes that this rupees 10 crore also. Then, how this ADJ will decide after decision of the Supreme Court and the district court, High Court, Supreme Court, and the arbitrary tribunal? How the ADJ will be able to decide now when this was the subject matter? Yes, states who appear for this.
Since 2008, we have appeared for PIPWD. We will appear in this.
The matter is of 2022, 2002,
2013, Lordship.
21 years.
14, Lordship.
21 years.
Lordship.
So, state, you are appearing for the state.
Yes, my lord. Amarjan law firm will appear in this case. We are waiting for instructions from the government.
You are for the government.
Yes,
I
my-
think you need to obtain instruction and then
Yes,
come prepare
yes,
with.
my lord.
This notice may also not be required to issue. So that is why, before issuing notice, let them give an opportunity
Lordship.
to obtain instruction.
Lordship.
Okay. Yes, who appears? Are you also in this case?
My lords, yes, my lords, I appear for the respondent. My learned friend is present in court. We are advocates from Shardul Amarchand Chandandas. We seek 4 weeks' time, my lords, to address the court on maintainability issues. Like my lords rightly pointed out, this is a 2008 award, my lords, which has been settled right up till the Supreme Court. And in fact, all claims of the petitioner, including all claims falling out of the termination of contract, have been dealt with under this award, which has attained finality by the blessing of the Supreme Court, my lords. My lords may fix this for 4 weeks later. We will address the court on maintainability, my lords.
4 weeks.
4 weeks, my
It's
lords,
okay.
yes.
Okay.
I'm grateful.
Hard. No, just a minute. Okay. Hard, Mr.
Tilal and Siyama.
Okay.
Tilal and Siyama, Lordship.
Okay. T. Lal Nunsiama, Land Council for the petitioner. Start. Huh? Okay. Who are the opposite party? State of Mizoram.
State
is
of,
not- okay.
Secretary PWD.
Also, Miss
Amarjan Makal, Ajoy Roy.
Lanet.
Ajoy Roy is also Sangipar. My lord, we filed KVA here also, we already,
Oh, here in this case.
yes, my lord.
Okay.
In the name of Ajoy Roy and Ms. Zoltan Sangipar, myself.
Okay. For the state of Mizoram.
Yes, we represent the state of
You
Mizoram.
government advocate.
We're not government advocate, but my lord, we will appear here. We are awaiting for the government instruction.
Okay. Who submits? Who prays for some time to obtain necessary instruction in this regard? Miss, you are for?
Zoltan Sangipar.
We are also appearing, Ms. Aishani Das is also appearing for the state, my lords.
Same.
For the government, my lords.
You are all appearing for?
For the government, my lords, for the
Government.
respondent, for the state of Mizoram.
They are also
Yes,
for
my
the
lord.
government.
Yes, my lord. Yes, my lord. They will also appear. We are a team.
Only the state is the party. So one is enough, I think, then.
Yes, my lord.
Okay. Okay. As prayed for by the Lana Council appearing on behalf of the respondent. 4 weeks.
Lordship, can we have a fixed date like 7th April?
Okay. And as requested by the Lana Council for the petitioner, list this matter on
7th April.
7 April.
7th April, Lordship.
Okay. Is it okay? 7th of April.
Yes, my lords.
Okay.
Yes, my lords.
Okay.
I'm so grateful.
Like your Lordship.
Item number 2.
May it please your lordship.
Yes.
By filing writ petition, the petitioners you have been sought for release of the fund contributed to the Employee Provident Fund organization, my lords. My lords, the brief facts is that the petitioners are employee of Apex Bank, Mizoram Cooperative Apex Bank Limited, my lords. So since the date of
What is your problem obtaining Aadhaar?
yes, regarding Aadhaar, my lords.
What is
Because-
your problem?
Because, my lords,
Is it difficult
as-
to obtain Aadhaar?
no, my lord, as
Everyone,
per,
everyone is having Aadhaar.
Yes.
Even after retirement also, it will help you.
my lords, as per my religious belief, so we are afraid to have Aadhaar card, my lords. We are afraid to have Aadhaar card because of their secrecy and some privacy, my lords. Because of their religious belief, my lords.
Aadhaar?
Yes,
in, Aadhaar, in
yes.
obtaining Aadhaar?
So that's why, my lords, they
No,
can,
that is for survival. Even after your retirement also, in order to get some benefits out from the government, you will be requiring this Aadhaar over and again. You'll be asked to produce the Aadhaar. This is your identity. So everyone is Christian, everyone is Hindu, whosoever may be, but then this Aadhaar is for the government. Government instructed, required you to have an Aadhaar. Even if you, even for going out also, you will be requiring Aadhaar. Aadhaar is necessary. What is the difficulty of obtaining Aadhaar?
my lords, as per their religious belief, they are afraid to have Aadhaar card, my lords.
No,
That is
everyone
the
having-
problem, my lords.
No, then none of the Christians, you're Christian.
Yes.
None of the Christians are having Aadhaar.
No, my lords, yes.
It's not like that. It's not like that. This that probably is not, I think, will not affect the religious belief. So I think it's better for you
Yes, my lords.
to live in this under the government. I think for your benefit only, not for anybody, huh?
My lords, that is correct, my lords. But my lords,
But then if they required, it appears that they have issued for 5 times notification requiring Aadhaar to link with.
my lords, after 2021 notification, so that 2021 circulars require mandatory seeding of Aadhaar card. So then, my lords, after in 2022 till 2025, mandatory seeding of Aadhaar has been extended, my lords. So that means,
It was extended 5 times,
yes,
4 times.
yes, yes,
So.
till
the-
2025.
Yeah, you were given ample opportunity to obtain
Lords,
other. It's a very simple one.
My lords, yes, that is correct, my lords. But in 2023, well, the mandatory seeding of Aadhaar has been extended. So the fund, withdrawal of fund have been submitted, but there is no response.
Then how do we direct that even if the Aadhaar is required also, but then you have to release because he has some problem? If it is if it has been made as a mandatory, then how do we direct against a
My lords,
mandatory requirement?
My lords,
That is there, but then what I'm saying is for your benefit.
yes, my lords.
Even after your retirement, in order to avail the beneficiaries from the government, you will be requiring Aadhaar only. It's always benefit. It will benefit you only.
That is correct, my lords.
So why should one be so that much religious would be a little bit you'll suffer. No one, but then you alone will suffer.
Yes, my lords. That is correct.
So
But my lords,
we
why-
can issue notice,
yes, my lords.
but then how it will help you unless you obtain.
But my lords,
Even if this relief is given to you, how it will help you in near future then? There also you'll file the case again. To obtain Aadhaar, you won't recover any money, but then to file case, you'll spend money. But then ultimately, if the relief is not granted, it will be difficult because everyone is having those, and then you are not exceptional.
my lords.
So with that, how long you will survive in everywhere with that Supreme Court ruling, isn't it? So, we'll issue notice then,
My lords.
but it's better you obtain Aadhaar.
My lords.
It's very easy, I think. So we can issue notice. You have anything
I'll
to
accept
say?
notice on behalf of the sole respondents, 1 to 4. On behalf of my senior Central Government Council.
Okay. Hard, Mr.
Yes, Van Lorshriata.
S. Van Landrieta, Land Council for the petitioner. Also hard, Miss
Bay Bilal Din Zwali.
Land Council appearing on behalf of Miss Jairam Sanghui, Land CGC. Respondent number. Respondent number
1 to 4.
1 to 4. Okay. Stop. The petitioners are the member of the Employees Provident Fund Organization. Oh, now it is called miscellaneous purpose. Okay. Having contributed the Provident Fund and the pension fund, huh? They have contributed the Provident Fund under the Employees Provident Fund Act 52. No, it is a, no, Employees Provident Funds and Miscellaneous Provisions Act 1952. And the pension fund, huh? However, the respondent issued circular wherein members of the Provident Fund organization are directed to mandatorily seeding their Aadhaar with universal account number for electronic challan cum return stuff. It is submitted that the petitioner did not have Aadhaar card, and due to this reason, the funds they have contributed to Provident Fund and Pension Fund are being withheld by the respondent to authority, although they have made an application for withdrawal of funds. Before the said authority staff. Para issue notice returnable by 4 weeks. Stop. Since Miss Lana Council appearing on behalf of the respondent has accepted notice, no formal notice need be issued. However, the petitioner shall serve extra copies to the Lana Council for the respondent staff. Para. List this matter after 4 weeks. Okay.
Deeply obliged.
Item number 3.
Please, Your Lordship. Lordship, though this matter was fixed for an admission hearing for today, the conducting counsel, Mr. Silaram Zhao, senior advocate, could not appear due to some personal difficulties. So, if this matter may be taken up next week.
Next week. Just
My lord, this matter has been pending since 2019, and there's a stay operating in favor of the petitioners right now. So, my lord, no further adjournment should be allowed after the next date, my lord. An attempt for disposal may be
Okay.
taken up.
so who is your senior?
Mr. Silaram Zawa.
You are also convergent with the case?
Yes.
Okay.
No, my lord. He's the conducting counsel, Mr. Senior. Sir.
This was actually supposed to be disposed of today.
Yes, my lord.
You are for the respondent.
Respondent number 5, my lord. Private respondent number 5.
So the lane which you are claiming,
Yes.
you have claimed,
Yes.
is under the allotment. It covers under allotment.
It's an LSC, my lord. It's my LSC. They are illegally occupying my
Yes,
occupying my
that is the,
LSC.
but then it was already acquired by the government earlier.
No, my lord. Only a part of it was acquired,
Not the present one,
not the present.
not the present land.
Yes, my lord. A part of the land was acquired, and then the land was made.
You have received the compensation also for that.
Yes, my lord. But it's made into a smaller LSC, which is still an active LSC, my lord. Valid LFC.
Okay.
Only a part of it was acquired, and that part was sliced out from my present LSC.
How much of land they are covering now at the moment?
Around 50 meters, my lord.
50 meter.
It's,
50 meter means long.
it's quite long, my lord.
Right.
It covers 3 houses, my lord. 3 Assam type houses.
Okay. 5 meter, 15 or 50?
Approximately 50.
50.
Yes, my lord.
That is length.
Yes, my lord.
And breadth?
Breadth is also around 50. It's like 50 meters.
Okay, that's
square.
quite a big
Yes, my lord. It's near the Ebenezer.
meter
Please.
or feet? Okay. This was to be disposed of.
Yes, my
actually.
lord.
And probably there are difficulties. You have a, you have a tough case. It will be difficult. And you did not participate there.
Yes, my lord.
It was ex parte.
But
Anyway, so you have any objection?
yes, my lord, I do have objections. It should be disposed as soon as possible, my lord, because we are being
But he's
denied
not
use
ready.
of my land.
You come prepare tomorrow.
I have to wait for my senior to conduct this case, my lord, if it's possible. My senior would be available next week.
Next week only.
If this matter may be taken up on Tuesday next week.
Tuesday.
All right, my lord, but without any further adjournments for disposal.
You are Mr.
Stephen Lalbuatsaya,
Land Council. Appearing on behalf of?
Mr. Sila Ramzawa.
Okay. Mr. So submits that the conducting council, Mr. C. Lal Ram Jawa, Land Senior Counsel for the petitioner. He is out of station.
Yes.
He is out of station. Therefore, pray for listing this matter next week. Start. Mr.
Rosang Zolaralte for respondent
Land
number 5.
Counsel for the petitioner. The Land Counsel for the respondent number.
5.
Okay, shown some urgency in the matter. And you are, okay, then her name first, okay? Well, is present and Mr. So-and-so, shown some urgency in the matter. Start. However, since the land conducting council is out of station, the matter stand adjourned. And as requested, list this matter on next Tuesday would be
17th March.
okay 17. Okay, and as requested, let this matter be fixed on 17.
Lordship, in the meantime, if the interim order passed,
Stop, huh?
continue.
The interim order passed earlier shall continue till then. Okay. Okay.
Lordship.
Interim order was passed in IA only, I think it appears.
IA.
The interim order passed earlier in IA. Huh? So,
It was in the main writ petition, madam. There's no IA. In the main writ petition.
in the main writ petition, no, in the main writ petition, it was denied. It was in the IA only.
Okay.
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 Item number 4.
Lordship, on behalf of the state respondents 1 to 4, I will be filing my affidavit in opposition by this week.
This week.
Yes, my lord.
Good news, yeah.
Okay. Mr. A.R. Malhotra, Land Counsel for the petitioner. Miss.
Caroline Kelwan, please.
Okay, Land Counsel appearing on the Land Government Advocate for the respondent, state respondent number 1 to 4 submits that the state would be filing their affidavit within this week. Within this week.
Yes, my lord.
Okay, and pray for listing this matter next week.
Lordship, I'm appearing on behalf of my senior for the respondent number 5, my lord.
Okay, respondent number 5 also
Yes,
not
ma'am.
yet filed.
Yes, my lord. If
Okay,
we may
the
be
Miss-
given
Miss
Daphne Shoitongi, my lord. Daphne Shoitwangi, on behalf of my senior,
Okay. Appearing on behalf of our senior Mr. Jesse
Lalun Sanga, my lord.
Lal Sangha, Land Council for the respondent number also made a similar prayer. So age prayed for Kama. So for 1 week time is granted to the Land Council for the respondent. So list is made
Your Lordship,
after-
in the meantime, if Your Lordship will kindly see the last order dated 14th of October.
Okay.
14th of October, Your Lordship.
Yes.
Your Lordship, as per the office note dated 10th of October 2025, service is not yet complete on respondent 8, 11
Oh.
and 17. In
Okay.
respect of whom,
There are other respondent also.
yes. So Your Lordship, the registry may be kindly directed to give a report regarding
Okay.
service of notice on respondents 8, 11 and 17.
Okay.
The rest have been served.
Just a minute. Not yet returned, no?
Your Lordship, as per the order dated 14th October 2025, notice on respondents number 8, 11 and 17, tracking consignment shows that items have been dispatched. So the registry may give a report regarding
I
the...
think there is some report.
Yes.
Just a minute.
Registry can give a report, Your Lordship, regarding the service of notice on respondents 8, 11, 17 after tracking the consignment.
There is some report. Trade consignment, just a minute. Says item received. 29/7.
Uh, 29/7 will be prior to the order dated 14th October.
This was probably obtained later on only, it appears. Okay. 29/7, 26/8. Item dispatched. Okay. Okay, as per the office note dated 9/3/2026, the service upon the respondent number 8, 11, and 17. Not yet, 17 are still awaited. So this is the same, I think, the item shown dispatched.
Yes, item dispatch. So a report may be given by the registry.
Okay, so this was long back, it appears.
They can track the consignment and give
Okay,
a report
so the,
whether it has
in
been.
view of the above, the the registry shall track the consignment. Somewhere it says item received. It was, of course, July, way back in the July only. This may be. What about the other respondent? This is in respect
they are-
of 8, 11, and 17.
Others have all been served,
Okay, but not appearing.
not appearing.
Okay. And submit the report, huh? By the next date. List is made after a week. After a week?
After
Okay.
You have to be, if a date may kindly be fixed then.
Then in that case,
Today
so
is
the next date is, and the next date as requested by the council for the parties is fixed on
19th of March.
19. Okay, 19 March. By 19 you file your affidavit. Okay.
Item number 5.
Lordship, I'm appearing on behalf of respondent number 8 and 9. May I seek another 2 weeks' time for filing affidavit, as our draft affidavit has not yet been returned.
Okay. Miss
Bay Bilaldin Zwali.
Line Council for respondent number.
8 and 9.
Okay, 8 and 9. Who appears for the other? 1 to 5. Have you filed affidavit? Okay, and then,
And for respondent number 6, and my lord, we won't be filing our affidavit.
okay, and then 1 to 5, no? Miss, her name, huh? Line Council, Line Government Advocate for the state respondent number 1 to 5. Prays for how much time you pray for?
2 weeks.
Further 2 weeks time. Have you obtained instruction? Received. Okay, some is that she has received received the paragraph's comment and prays for further 2 weeks time to file affidavit in opposition. Miss, have you also received instruction? Okay, Miss so and so, huh? And counsel for the respondent number
8 and 9.
8 and 9. Made a similar submission and prays for 2 weeks to file affidavit in opposition. Stop. Miss
Ruth Dalwat Feli for respondent number 6.
Lana Council appearing on behalf of the respondent number 6. Some is that the Miss so and so, some is that the respondent number 6 would not be filing affidavit in opposition. And who are for the other? Whether the other respondents, there's a lot of respondents, whether the other respondents appeared earlier? Land Council for the petitioner, have they appeared?
No, they have not appeared. Respondent number 10. 7
Okay.
and 10.
Have you taken steps upon that?
Yes.
No one appears on behalf of the other respondents. Okay, stop. Yes, prayed for comma the state respondents and the respondent number 6 and 8 are granted further 2 weeks time to file their affidavit in opposition. Stop. List this matter after 2 weeks. Okay.
Right.
Item number 6.
Yes.
May I please, Your Lordship?
Yes.
My Lord, this matter was taken up yesterday. The matter pertains to challenging the ex parte order, wherein my application for setting aside the ex parte order before the land trial court was rejected. I have approached this honorable court to set aside the impugned ex parte order as well as the order rejecting my application for setting aside the ex parte order. The instant appellant is the defendant before the land trial court. And on the day fixed for appearance, my lord, his counsel, although already prepared the vakaratnama and written statement, had first appeared before the court of learned district judge. And on that day, unfortunately, the learned district judge had functioned his court at his judicial quarter. due to medical reasons. And after finishing his matters, as many as 13 matters he had on that day, he approached the learned trial court, which is about 6 to 7 kilometers from the judicial quarter, my lord. After reaching the court premises, my lord, the impugned ex parte order was already passed by the learned trial court. And on the following day, my lord, the counsel for the defendant had filed the application for setting aside the ex parte order, but that was rejected. And being aggrieved, my lord, the appellant defendant is before this honorable court. If I may take a lordship to the page number 32. Page number 32 of my appeal, my lord.
30?
32. This is the first order passed by the learned trial court. Page number 32, running page number 32. Order dated 16/12/2024. Have you got it, my lord?
32?
Page number 32.
Yes.
This is order dated 16/12/2024. This is the first order passed by the learned trial court after the respondent plaintiff filed the money suit. And as can be seen from here, my lord, on the second last paragraph, my lord, issue summon to the defendant. The plaintiff is directed to serve summon to the defendant along with copy of the plaint. And 13/2/2025 was fixed for written statement and appearance of the parties. This is the first order, 16/12/2024. And on the following page, my lord, if I may take your lordship to the following page, page number 33. First order was issued on 16/12/2024, fixing the next date for 13/2. And what happens on 13/2, my lord? Page number 33. Page number 33.
Yes.
It's written like this. The plaintiff is present to counsel and submitted service report summons returned in respect of the defendants. Court is adjourned due to trial judge is out of station. Fixed 26/3/2025 for written statement. So on the next day, 13/2, court is adjourned. And thereafter, my lord, on 26/3, on the bottom of the page of page number 33,
Yes.
plaintiff is present through counsels. Today is fixed for written statement. The defendant fails to appear before the court. Let the summons be issued again before the proceeding of ex parte. Fixed 24/4/2025 for written statement. Reissue summons to the defendant.
No, on 13, the defendant appeared,
No, my lord.
not appeared.
Court is adjourned on 13.
Okay. So on 16,
16 is the first day of
okay, the
issuing the
defendant did
notice.
not appear. Okay.
On 13, on the next day, on the second day, court is adjourned. And
Okay.
on the third day, the learned trial court had directed for reissue of summon
Defendant
to
did
the
not
defendant.
appear.
Yes, my lord. And if I may take a lordship to page number 34,
Yes.
order dated 24/4/2025, handwritten, my lord. Handwritten one.
Yes.
Plaintiff is present through counsel. Defendant is absent. Since summons were not issued on the last court date, let fresh summon be issued. Accordingly, 15/5 was fixed for appearance of the defendant, and direction was made to reissue summons to the defendant through plaintiff's counsel.
Okay. Fixed on 15.
Fixed on 15. And coming to that 15/5, my lord, the impugn order. This is the impugn order, page number 35.
So the defendant never appeared.
Never appeared nor received this amount in the past. By this order 24/4/2025, direction was made to reissue summon. This summon we have received. The defendant appellant had received the summon issued on 24/4. Accordingly, my lord, on the next date
Summon
fixed,
to the defendant or plaintiffs is present. Okay.
on the date fixed for appearance on 15/5, my lord.
Okay, this was the first time that summon was duly served.
Yes, my lord. And on this day, my lord, the appellant defendant had engaged his counsel. His counsel also prepared the vakalatnama to be submitted on that day. But on that same day, my lord, the learned district judge was unwell, and he conducted his court in the judicial quarter.
Okay, where do we find that statement? Have you made that statement?
Yes, my lord. Yes, my lord.
That the
Before
court-
before I take a lordship to the present appeal, my lord. Page number 50. Page number 50. Running page number 50. 50. This is the application filed by the defendant appellant, instant appellant, before the London Trial Court, seeking for setting aside the impugned ex parte order.
No. Where have you stated that on that day, on 15/5/2025?
Yes, my lord. It's
It
written,
is here.
it starts from here, my lord. In my application before the London Trial Court itself, where I
Okay,
seek
this
for
is
setting aside,
This is application for
setting aside the ex parte order,
before the
London Trial Court, on the
Same court.
Same court, as per the order dated, as per the
Okay.
order 9, Rule 13 of CPC.
where is that statement?
Yes, my lord. Para 5, page number 52. Para 5, paragraph number 5.
Yes,
May I read?
yes.
That while the applicant was in Aizawl for caring his ill mother, he used to contact his admired lawyer and took legal advice from him. As per the advice of his admired lawyer, the applicant again hurriedly came home early in the morning on 15/5/2025 by one vehicle, Sumo, bearing registration number such and such for his case, and soon after he reached Champhai, he engaged lawyer namely Tila Famkima, known as Thatea, and he executed Vakalanama on the same date. That engaged lawyer of the applicant was very much busy on that particular day. Since he had engaged so many cases in different courts at Champhai, he appeared the whole forenoon at the highest court within Champhai Judicial District, that is, District and Session Judge Cum Special Court and the NPS Act, which is situated at Tlang Road, Karot Veng Tlang Champhai. It is submitted that District Judge Cum Special Judge in the NPS Act is currently functioning at his residential quarter. Since he is medically unfit for functioning from the courtroom, the distance between the residential quarters of
This was dismissed by which court?
the same court.
Okay,
I have taken this ground on before the same court, my lord.
okay,
May I continue?
yes.
The distance between the residential quarters of the judge, which is situated at IIDC Zote, is around 6 to 7 kilometers. When the applicant counsel tried to submit Vakalatnama and written statements in the afternoon at around 3:30 p.m. before the Nile trial court, no sitting judge was available on the trial room, on the court. And on the same day, the applicant counsel requested the Pesker of the trial court to see what order had been passed on 15/5/2025 in Munisud number such and such. And on reply, the applicant counsel came to know that ex parte order against the applicant has already been passed. This clearly shows that the applicant was not given the opportunity to submit Vakalanama and written statement on 15/5/2025. In the meantime, the applicant is fully interested in the case and duly ready for defending the instant case within time, and so far he gave efforts in all possible ways. And my lord, coming to the impugned order passed by the London trial court in this application, which I have annexed just next to the index of my appeal on the beginning of the appeal, next to the index, my lord.
Okay.
Have you got in, my lord, CMA number 22/2025?
Yes. Yes. Para?
From para 8, I'll read, my lord. The foregoing paragraph were the same averments which I've just read out. I'll read from para 8, my lord.
Para 8.
Para 8 onwards, my lord. I have heard the submissions of both parties and perused materials on record. At the outset, it is borne in mind that although the law is that the defendant is to file written statement within 30 days from the date of service of someone on him, extendable of 90 days, if allowed by the court. The grounds for setting aside an ex parte order have also been provided in Order 9, Rule 13 in the CPC, which is reflected herein for easy reference. I'll skip this for the moment. Continue from para 9, my lord. As reflected above, to occasion setting aside of an ex parte order, this court is to see whether summons was duly served upon the person being called upon. The other instance on which setting aside this occasion is when,
Just a minute.
Yes, my
When,
lord.
when was the first it was filed? 16/12/24, and then 15/5. 2/25, 3/25, 4/25, and 5. Okay. Yes.
Para 9. As reflected above, to occasion setting aside of an ex parte order, this court is to see whether summons was duly served upon the person being called upon. The other instance on which setting aside this occasion is when the person summoned was prevented by any sufficient cause from appearing on the date fixed. Para 10. In the instant case, perusal of the materials on record shows that summons in vernacular was personally served on the applicant on 15/1/2025 and 25/4/2025. Further, in addition to the summon returns submitted by the learned counsel for the opposite party, it is the submission of the said counsel that he had even informed the applicant of the other court dates, fact which has been not rebutted by the learned counsel for the applicant. Admittedly, the applicant used to contact his counsel during his stay at Aizol, which goes on to show that he had ample time to execute Wakalatnama to be submitted on time. While this court refrains from commenting on the submission that the applicant's counsel could reach this court only by 3:30 p.m. due to his appearance before the court of district and session judge at his residence. Other than the fact that this court does not recall the alleged attempt to submit Wakalatnama at 3:30 p.m., it cannot be fed home as to why the applicant could not personally appear before this court on the date fixed. Therefore, upon hearing the submission of both parties and perusal of materials on record, this court is of the considered opinion that the grounds set out by the applicant does not tantamount to sufficient cause within the meaning of Order 912 of CPC so as to warrant setting aside of this court's ex parte order. According to the learned trial court, my lord, from what can be seen from the Para 10 which I've just read out is that, according to the learned trial court, even if the learned counsel could not appear on that day, the defendant himself should appear in person. That is the expression given by the learned trial court. But my lord, in the present case, as I have pointed out earlier, 16/12/2024 was the first time notice was issued. 16/12/2024. And on the next date, that is 13/2/2025, the court was adjourned. And again, on 26/3/2025, direction was made to issue summon to the defendant. But on the next day, that is on 24/4/2025, the court itself observed that summon has not yet been issued to the defendant. So a fresh direction was made to reissue summon. And accordingly, on 24/4/2025, summon was again reissued, fixing the next date for 15/5. And my lord, the appellant defendant, with due diligence, had appointed his counsel, who also prepared a written statement and Wakalatnama, prepared for submitting on the 15/5. But unfortunately, on that day, the learned district judge was unwell, who could not hold his court in the court premises. And while attending the court, functioning in the judicial quarter, my lord, as soon as they have finished the court, they had approached the court premises of the
So
learned
here,
court.
the notice was served. In this case, notice was served upon the respondent.
Yes, my lord. I have taken dusty steps upon the sole respondent by hand. And I have also filed an affidavit indicating the service of notice that we have duly served it to the present respondent. In spite of that, my lord, the respondent do not appear till date. And the money suit at this stage is in the stage of filing of written statement. But as a result of
It was a state.
state, my lord,
Okay.
due to this filing of this present appeal.
Okay. So, what is IA for?
I is the application for stay of the suit.
Okay. Okay. Pass order.
Yes, my lord. So my humble prayer is that the impugn order dated 16/7/2025, passed in the misapplication. My application for setting aside the ex parte order may be set aside, and as well as the impugn order wherein ex parte order was held on 15/5/2025 may also be interfered with, and I may be allowed to contest the suit on merit. My prayer portion is in page number 18, my lord, of my memo of appeal, page number 18, para 12.
Okay. Page?
Page number 18, para 12.
Your prayer is to set aside the 16/7/2025 as well as 15/5/2025.
Yes, my lord.
Okay.
There's a sufficient cause for the defendant's counsel,
Okay.
which prevented him from appearing on that day.
Hard, huh? Hard, Mr.
Victor.
Victor El Ralte, learned counsel for the appellant. No one appears on behalf of the respondent. Okay, so I'll pass order. Okay, give it in chamber.
Deeply obliged.
Item number 7.
May please, Your Lordship. Your Lordship, the leading counsel in the matter are based in Delhi, and we have taken the consent of the respondent parties if this matter can be fixed on 1st of April.
What is this IFO?
For deletion or expunge of the name of JICA from the matter.
Okay, yes. Remember. So they have filed objection also.
Yes, the private party, the private respondents have filed their objection, but then other parties have submitted that they will not be filing any affidavit of opposition.
Lordship, I'm appearing on behalf of respondent number 83, on behalf of my senior CGC. Lordship, on the last court date, 3rd February 2026, I submitted that Union of India will not be filing any objections. However, in the court order dated 3rd February 2026, it is stated that CGC may be allowed to adopt the objection filed by the private respondents. If Your Lordship may kindly clarify this point and have it recorded in the order.
Not be filing any affidavit in opposition, may be allowed to adopt the objection filed by the private respondent. So you have no objection at all?
Yes, my lord.
They have submitted in the last court that they will not be filing any affidavit in opposition, that's it. But then the learned counsel for the state was reflected as the Union of India's submission.
Okay. But then in any case, the objection of the other will be relied upon, but you have no objection at all. You want to, you want this sentence to be corrected?
Yes, my lordship.
This amount to review then? No.
No, I don't know.
Hmm? There is an order already
Yes.
passed.
Let it be the
Oh, let it be, Your Lordship.
Or it can be recorded as a fresh submission, Your Lordship, that they will not be filing any affidavit in opposition, that's it. Till that much, without making it a review. In my humble opinion, that can be done.
Okay. Mrs. Mary L. Kante, Land Counsel for the applicant who submits that the conducting counsel
Yes.
is out of station.
They are based in Delhi.
Oh, they are is based in Delhi.
Yes, my learned friend is appearing on the line.
So they are appearing
Yes. They want to appear physically.
physically.
Yes.
Okay, okay. In Delhi, and some is that they want to appear physically, and therefore matter may be fixed on
1st of April.
1st of April, to which the Land Council appearing on behalf of the respondent has no objection. Have no objection. Okay. Stop. Prayed for, comma, list this matter on 1st April. Stop. Para. So, Miss
Baby Laldin Zwali.
Land Council appearing on behalf of
Respondent number
Ms.
83.
Jairam Sangpuri, Lanak CGC, for the respondent number 83, submits that on 3/2/2026. This amounts to then typographical error or whatever maybe, but then it amounts to it. Okay.
Fresh submission, I can't record here. Without going to that order more. Anh nhìn đọc kinh. Anh nhìn nhận hết thì mấy.
Submit that the respondent number appearing for the respondent, and that would be appearing on behalf of Ms. Jairam Sampui Lanak CGC for the respondent number 83. Submit that on 3/2/2026. While submitting that, the respondent, that the Union of India would not be filing any affidavit in opposition. Has also submitted that they may be allowed to adopt the objection filed by the private respondents in their affidavit in opposition. What did I say? The sentence? Well, no. The beginning sentence is beginning. While okay. Now she clarifies that the now she clarify on instruction that the Union of India would not be filing any affidavit in opposition, and also will not adopt the objection filed by the private respondent. Okay, in their affidavit in opposition. Okay, stop. In view. Okay, then who else?
Lordship, I am appearing on behalf of the state respondents 85 to 88. We will not be filing any written objection. However, we will be adopting the objection made by the private respondents.
Okay, this was actually your submission
Yes, my lord.
in the last occasion submitted the state. Okay, this is there only. Okay, and Ms. So-and-so appear on behalf of the state respondent number 85, 86, 87, and 88. And
NHIDCL.
Your Lordship, I'm appearing on behalf of my senior Samuel Valashada, who is representing respondent 84, 89, and 90. Will not be filing any written objection and will be adopting the objection made by the private respondent.
okay. Ms. So-and-so, Lana Council appearing on behalf of. You are appearing on behalf of?
Samuel Valashada.
Okay, Valesha. Lana Council for the respondent number 84, 89, and 90.
90.
Submit that. Although they would not be filing affidavit in opposition.
Your Lordship, if I may, I think the submission has already been recorded earlier in the
They are-
earlier order.
Appearing
Because the last court day they were present and submitted that they will not be filing the affidavit in opposition, that's it.
No, there, this submission is not there. That they will be adopting is not there. However, they will not be filing affidavit in opposition. However, they would be. However, praise that they may be allowed to adopt the objection filed by the private respondents. Okay, and who else? That's all. Okay.
Lordship,
Therefore-
I'm appearing on behalf of all the private respondent.
Respondent number?
All the private respondent. Number 1 to
82.
82.
Okay. Mr. So-and-so appear on behalf of the private respondent number 1 to 82. Okay, stop. Para. Is prayed for by the Land Council for the applicant, not been objected to by the Land Council for the respondents. List this matter on the
1st of April, Your
1st
Lordship.
of April. 1st of April.
1st of April.
Okay. Okay.
Deeply obliged.
Item number 8. May it please your Lordship. Yes. Lordship, this is a bail application, Lordship, and the charge sheet has been received by the accused, Lordship, and I believe we can proceed with the hearing, Lordship.
So the case has been charge sheeted.
Yes, Lordship.
Yes, Your Lordship, in the last court date, I was instructed to get instructions as to the stage of the trial. Now, the stage is document delivery stage, DD stage, and it is fixed on 17/3/2026.
DD stage?
Yes, delivery of documents for handing out the charge sheet to the accused.
Okay, okay. Earlier 207.
Yes, yes.
Complied with? Copy furnished to him?
On 17/3/2026. Did all.
Okay, this is case record. This is trial court record.
Yes, that is a trial court record without the note sheet.
Without note sheet.
So since there was no note sheet, I have obtained instructions on the next date. The next date is fixed on 17/3/2026 for delivery of documents.
Okay, delivery of documents.
So on that day, they will be
So
giving
what is
the
the
copy of
offense
the charge.
otherwise alleged
Lordship,
against
he was
accused?
charged under 22C 29 of the Indian PS Act, Lordship. 22 and 29 of the Indian PS Act, Lord. 22C and 29.
22C.
Yes, Lordship.
How long you have been there inside?
Our Lordship, as of today, we are in 172 days and under custody, Lordship.
172 days.
Yes, Lordship. And now that Lordship, the charge sheet has been filed, Lordship, we have some submissions, but among that, custodial interrogation is no longer necessary, Lordship. On top of that, Lordship,
No, you have filed any bail application, moved any bail
it has been
application
filed
before
in
trial
the,
court?
yes, Lordship. It has
So
been,
how many times?
It has been filed twice as per my knowledge, Lordship.
Rejected twice.
Rejected twice, Lordship.
What is the last, when the last was?
The last
was
order
rejected?
is on
24th October.
we have annexed it on as annexure number 3, page number 15, Lordship.
What ground it was rejected?
The grounds is given on page number 18, Lordship, and paragraph number 4. Now, if I may go to Lordship. I have heard both the parties. I have perused the case record. This is in connection with the seizure of huge quantity of 70.200 kilograms of
Quite a
methamphetamine.
large.
Yes. The accused in custody for only 2 months. There is grounds of arrest and intimation of arrest. Earlier bail application was rejected. Virtually no new grounds. I am not convinced by the submission of the learned counsel for the petitioner that the accused will not be guilty of the offense. Culpable mental state must be presumed as against the accused. Section 35 and 54 of Indian PS Act. Bail is rejected at this stage, Lordship.
So, what according to you is the new ground this time?
Lordship, the statutory
So only the
prob-
charge sheet filed?
The charge sheet has been
Charge
filed,
sheet
Lordship.
But then the next date is fixed on, it's 17th.
17th, Lordship.
On which date, only the document will be furnished on that day?
Yes, Lordship.
Charge again another date for CC,
Yes, Lordship, again.
another date.
So now considering that he's in 172 days, Lordship.
Now
in
what,
custody-
I think the trial court is the best court to consider your bail at this moment.
I believe so, but
Since
Lordship,
it was, I think, before the filing of charge sheet, this bail rejection.
yes, and this bail application was filed before the charge sheet was filed, Lordship.
But then subsequently charge sheet filed.
Yes, Lordship, I believe.
So what is your submission?
Your Lordship, if my learned friend is done with the submission,
No,
then
Lordship, I do have some submissions for the application, Lordship.
What is the new ground you have taken?
Lordship, there are reasonable grounds, Lordship, with this.
Because
Lordship. As
this-
per the Lordship, as per section 37 of the Indian PS Act, Lordship,
Mhm.
it has 2 conditions, Lordship. First of all, the condition is that opportunity must be given to the public prosecutor, and the second is there must be some reasonable doubts, Lordship. Lordship, there is a reasonable doubt is because, Lordship, as per the FIR, Lordship, the charge sheet, Lordship.
See, the land court has observed, you have just read it. There are no ground for arrest and then intimidation. Virtually no new grounds. I'm not convinced that the submission of the so there is that the accused will not be guilty of the offense.
Yes, Lordship.
Mhm.
So now, Lordship, section 35 and 54, Lordship, arises only after the conscious possession has been proved by the prosecution, Lordship. Now, Lordship, here there is a reasonable grounds, Lordship, that the accused does not have any conscious possession, Lordship. With this regards, I have 2 citations, Lordship.
Okay, this was recovered or the seized from where?
It was seized from sand, Lordship. It was just mentioned by the FIR that it was
Seized from?
under the sand, Lordship. It was just mentioned as per the FIR, Lordship. which we have submitted in our petition, Lordship. It's given in page number 22, Lordship.
Yes.
Now, Lordship, if I may go through this. To the officer in charge, Champhai Police Station, submission of FIR. I beg to state that on 19th of September 2025 at approximately 6 a.m., while I was on duty at Champhai Police Station, I received information from Zokathar Police. They informed me that one individual had been detained at Zotlang Champhai under suspicion of possessing contraband substances, and they requested that necessary legal action be initiated at the earliest. In response to the said information, I, along with party led by P. Lalrin Zwali, immediately departed from Champhai Police Station for Zotlang Champhai after engaging and securing the presence of two independent and reliable civilian witnesses in compliance with legal procedure. Upon arrival at the location, I formally documented the information in writing, and at approximately 7:30 a.m., we conducted a thorough search of the area. During the search operation, we recovered and seized a total of 65 bundles suspected to be methamphetamine. Each of the 65 bundles contained 5 small bundles, and each small bundle consisted of 10 sachets, with every sachet holding 202 red tablets, including 2 green tablets. In total, 6,56,500 tablets, weighing approximately 70.200 kilograms, were recovered. The contraband was found concealed inside a white nylon sack, buried under the sand by the accused, named as Lalnunthara, son of such and such.
This is you?
This is, yes, though, Lordship, the accused petitioner. So now, Lordship, as per the FIR, it was just mentioned that it was buried under the sand by the accused, Lordship. There is no any other documentary evidence to prove that it was the accused who, in fact, Lordship, no contraband was seized from his possession.
No, just this buried by under the sand by so and so.
Yes, Lordship.
Who led to the recovery?
Lordship, as per the FIR, it was mentioned here that he was informed by the Zokathar police at 6 a.m., Lordship. And after that, after receiving the information, they proceeded to the location, Lordship.
So at that time, the accused was not present.
The accused, Lordship, as per our submission, is that, Lordship, he was taken from his residence at Dinthar at 2 a.m. in the morning, Lordship. And the ground of
2 a.m.
Yes, 2 a.m. in the morning. And the ground of arrest was given to him only at 7:40 a.m.
No. So the police themselves went on the disclosure by somebody, not by the accused.
Not by the accused, Lordship. Here it was mentioned here that after I received information from Zokathar police, Lordship. So the information was received from Zokathar police, Lordship.
Where from they are saying that it was buried by the accused?
It's mentioned here, Lordship, that
it's mentioned here, but then anywhere the statement,
yes,
or in the record mentioned that it was who led the police to recover this?
No, Lordship, the
The
information.
place. Only on the information it was the police themselves have found out the place.
Yes, Lordship. The information is given in page number 21, Lordship, of the petition.
Now, where the accused was when these items was recovered? The tab.
Lordship, as per our submission, Lordship, that we were detained from our residence at Dinthar at 2 a.m.
Prior to the recovery?
Prior to the recovery, Lordship.
Okay, prior to the recovery.
Yes, Lordship. So then after that, we were taken to the police station for inquiry. And once the contraband was found, and we were just implicated in the case, Lordship. That is our humble submission.
Okay, first you were taken
From
by
our
the
residence
police
at 2 a.m., Lordship.
to the police station.
Yes.
And how far it is? the
Lordship,
police station
along
and-
with, if I also mentioned that I, along with my brother, was also taken from my residence, Lordship.
Okay.
And
So this sand is located where? The sand is located?
around approximately 11 kilometers from my residence, Lordship.
Does that land belongs to anybody?
Lordship, it's given in the, as per our page number 19 of annexure number 4, Lordship. The address is given here. Is
No,
that,
whose land that belongs to?
Lordship, it's given here, what's mentioned here is that near residence of Chal Sailava of Zotlang Champhai
That is
bypass
different
road.
person. Different person.
There is a different person, Lordship. It is nowhere linked to us, Lordship. It is nowhere in our possession or control, Lordship.
Who gave this information you said?
Lordship, the information is given in page number 21. So, Lordship, information recorded. Now, Lordship, if I may go through this, Lordship.
This individual detained at Jotlang is you.
Yes, Lordship. Now, Lordship, if I may also mention that in the FIR, as per the FIR, Lordship, it is given that here it's mentioned that upon arrival at the location, I formally documented the information in writing. And at approximately 7:30 a.m., we conducted a thorough search of the area. And now, Lordship, the grounds of arrest was given to him, which is in page number 33, at around 7:40 a.m. So, this is to say that the search had been conducted only within 10 minutes, Lordship, and the ground of arrest was given to him at 7:40 a.m., while he was already detained in the police station around 2 a.m. in the morning. So now, Lordship, this clearly violates Article 22(1) of the Constitution of India, Lordship.
It was revealed by the accused himself, disclosed by himself.
Lordship, as per the FIR, Lordship, it has been mentioned here, Lordship. But also, Lordship, the sand has been, we have mentioned in our submission, Lordship, the sand was delivered through a truck, Lordship. Through a truck, Lordship. We have mentioned in our petition, Lordship. So the sand was already in a truck and it has been unloaded in that particular location, Lordship. And
Okay, so it was
neither the truck driver, neither
this was also unloaded in the truck.
in the truck. It was loaded in the truck, then it was unloaded.
Okay.
But
So
nowhere,
it was not deliberately buried by the person.
not
but
deliberately
in the
buried,
truck
Lordship.
only.
Yes.
Okay. that
No,
is
but then it was unloaded in the bypass road, Lordship, in a particular location.
So it was there.
It was there, but it was not, the truck was neither seized, neither it belonged to the accused, Lordship.
Truck was not seized.
He was not seized, Lordship. Neither was the
Truck
driver of
driver?
the truck. Neither was he arrested, Lordship.
Okay.
No, Lordship, we're not
And
disputing.
probably the detail has to be considered by the trial court, it appears.
I believe, but Lordship, we're not disputing the facts here, but Lordship, all we're saying is that Section 37,
Mhm.
the twin condition of Section 37, Lordship, it fulfills the grounds of Section 37, Lordship, the twin condition, which, Lordship, is that with reliance to my citation, Lordship,
Mhm. What section 37 says?
Section 37, if I may go to Lordship. Offences to be cognizable and non-bailable, notwithstanding anything contained in the Code of Criminal Procedure 1973. And every offence punishable under this Act shall be cognizable. No person accused of an offence punishable for offences under Section 19 or Section 22 or Section 27A, and also for offences involving commercial quantity shall be released on bail on his own bond unless the public prosecutor has been given an opportunity to oppose the application for such release, and where the public prosecutor opposes the application, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. So now, Lordship, as per the subsection 2, Lordship, there are reasonable grounds, Lordship, to believe that the accused is not guilty, Lordship, because
But the trial court, while rejecting bail, has made already an observation. This observation.
yes,
that
Lordship,
there
it has made, Lordship, but So, Lordship, the new grounds which we are mentioning here is that, Lordship, as per the, during that time, Lordship, the police report was incomplete when we received, Lordship. So now, as per when we filed this bail petition, there were some new documents to show that there are reasonable grounds, Lordship. Also with reliance to our citation, Lordship. So it is our only submission, our humble submission is that, Lordship. As per the citation, if I may, the State of Kerala versus Rajesh, the relevant paragraphs is paragraph number 18. Page number 4, Lordship.
Yes.
Yes. So, Lordship, the jurisdiction of the court to grant bail is
Para 15.
Para number 18, Lordship, page number 4.
18.
Yes, 1-8.
Yes.
The jurisdiction of the court to grant bail is circumscribed by the provisions of Section 37 of the NDPS Act. It can be granted in case there are reasonable grounds for believing that the accused is not guilty of such offense and that he is not guilty to commit any offense while on bail. It is the mandate of the legislature which is required to be followed. At this juncture, a reference to Section 37 of the Act is apposite. The provision that makes the offense under the Act cognizable and non-bailable, it read thus, Section, this is, Lordship, the Section 37 of the Indian PS Act, it's mentioned here. Now, Lordship, the other relevant paragraph is paragraph number 20.
Yes.
Yeah. The scheme of Section 37 reveals that the exercise of power to grant bail is not only subject to the limitations contained under Section 439 of the CRPC, but it is also subject to the limitation placed by Section 37, which commences with non-obstante clause. The operative part of the said section is in the negative form, prescribing on the enlargement of bail to any person accused of a commission of an offense under the Act, unless twin conditions are satisfied. The first condition is that the prosecution must be given an opportunity to oppose the application, and the second is the court must be satisfied that there are reasonable grounds for believing that he is not guilty of such offense. If either of these two conditions is not satisfied, the ban for granting bail operates. Now, also the relevant paragraph is paragraph number 21, Lordship. The expression reasonable ground means something more than prima facie grounds. It contemplates substantial probable cause for believing that the accused is not guilty of the alleged offense. The reasonable belief contemplated in the provision requires existence of such facts and circumstances as are sufficient in themselves to justify satisfaction that the accused is not guilty of the alleged offense. In the case on hand, the High Court seems to have, Lordship, this is the relevant anymore. Now, so Lordship, also Lordship, I would rely on the Mohanlal versus State of Punjab citation, Lordship. The relevant paragraphs is in paragraph number 10.
Yes.
Unlike the general principle of criminal jurisprudence that an accused is presumed innocent unless proved guilty, the NDPS Act carries a reverse burden of proof under Section 35 and 54. But that cannot be understood to mean that the moment an allegation is made and the FIR recites compliance with the statutory procedures leading to recovery, the burden of proof on the very inception of the prosecution shifts to the accused without the prosecution having to establish or prove anything more. The presumption is rebuttable. Section 35(2) provides that a fact can be said to have been proved if it is established beyond reasonable doubt and not on preponderance of probability. The stringent provisions of the Act, such as Section 37, the minimum sentence of 10 years, absence of any provisions of remission, do not dispense the requirement of the prosecution to establish a prima facie case beyond reasonable doubt after investigation, only after which the burden of proof shall shift to the accused. The case of the prosecution cannot be allowed to rest on preponderance of probabilities. Now, also, Lordship, paragraph number 11. A fair trial to an accused. A constitutional guarantee under Article 21 of the Constitution would be hollow promise if the investigation in an NDPS case were not to be fair or raises serious questions about its fairness apparent on the face of the investigation. In the nature of the reverse burden of proof, the onus will lie on the prosecution to demonstrate on the face of it that the investigation was fair, judicious, and nor circumstances that may be raise doubts about its veracity. The obligation of proof beyond reasonable doubt will take within its ambit a fair investigation, in absence of which there can be no fair trial. If the investigation itself is unfair, to require the accused to demonstrate prejudice will be fought with danger, vesting arbitrary powers in the police, which may well lead to false implications also. Investigation in such case would then become an empty formality and a farce. Such an interpretation, therefore, naturally has to be avoided. Now, let's check the other relevant paragraphs is 13, 14, and 25.
Okay.
Paragraph number 13. The duty of the prosecution under the NDNPS Act, considering the reverse burden of proof, was noticed in Noor Agra Supra, observing an initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. Even then, the standard of proof required for the accused to prove his innocence is not as high as that of the prosecution. Whereas the standard of proof required to be prove the guilty of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. Now coming to paragraph number 14. In a criminal prosecution, there is an obligation cast on the investigator not only to be fair, judicious, and just during investigation, but also has the investigation on the very face of it must appear to be so. Ensuring any conduct or impression which may give rise to a real and genuine apprehension in the mind of an accused and not mere fanciful, the investigation was not fair. In the circumstances, if an informant police official in a criminal prosecution, especially when carrying a reverse burden of proof, makes the allegation, is himself asked to investigate, serious doubts will naturally arise with regard to his fairness and impartiality. It is not necessary that the bias must actually be proved. It would be illogical to presume, and contrary to normal human conduct, that he would himself, at the end of the investigation, submit a closure report to conclude false implication with all its attendant consequence for the complainant himself. The result of the investigation would therefore be a foregone conclusion. Now, Lordship, our main contention here is the Lordship, the twin condition, Lordship, of under Section 37, which is that, Lordship, the possession, Lordship, has not been proved beyond reasonable doubt, Lordship. So, Lordship, there is reasonable doubt, Lordship, and also, as mentioned earlier, Article 22(1) of the Constitution of India has been violated, Lordship, when he was detained from his residence at 2 a.m. However, the grounds of arrest was given to him only at 7:40 a.m., Lordship. Now, Lordship,
he was arrested on?
On 19 September 2025, 2 a.m. from his residence.
19 September.
Yes. Now, Lordship, it has been already 172 days, which is nearly 5 months for the charge sheet to be filed, Lordship. Now that, Lordship, the investigation has been completed, Lordship, and also, Lordship, he is a permanent resident of Champhai, Lordship.
Now, when the recovery was made?
The recovery was made around 7:30 a.m., Lordship, as per the FIR, as per the document, Lordship.
7:30 a.m.
Yes.
That was after your arrest. That is possible.
Yes, but as per Article 22(1), Lordship, immediately after he has been detained, Lordship. That is the Lordship. If I may read Article 22(1), Lordship. Lordship, Article 22, protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice.
No, it was on the same day.
On the same day, Lordship.
Recovery was also made on the same day,
Yes,
19/9 only.
But, Lordship, if he had been already detained from his residence at 2 a.m., Lordship, there is already some grounds to believe that some contraband substance has been suspected of being hidden, Lordship. But, Lordship, in this case, Lordship, nothing was recovered from his possession, Lordship, from his personal possession.
No. So, according to you, who disclosed?
Lordship, as per the information which we received, Lordship, there are certain persons who are involved in this case, which is has been mentioned in the charge sheet.
It was only after his arrest and probably being disclosure statement made by him only, it was recovered at 7:30 a.m. on the
Lordship,
same day.
but it was not within his residence, Lordship. It was in a separate residence, in a someone. It's in a separate
Outside
property.
residence only, but then how it was how the recovery was made? Who disclosed, according to you?
Lordship, we did not go through. Means we received the charge sheet, but since it cannot be submitted right now, Lordship.
Okay. Yes. Anything else?
Lordship, yes, that will be all, Lordship. And if I may be given opportunity to make a rebuttal, if I may be given opportunity to make a rebuttal,
Make a
additional submission, Lordship.
okay. Yes.
Your Lordship, first of all, my learned friend have submitted that he was detained and taken from his residence at 2 a.m.
Yes.
Now, that is just his statement. Now, what we can see from the record in the application, coming to page number 22, that is the FIR,
Yes.
which my learned friend have read out,
Hmm.
it says that the SI in charge have received information at the police station at around 6 a.m. Now, the distance between Champai and the place of occurrence, that is Zokotar. Zokotar is a bordering village of Myanmar. So it's about, if I'm not mistaken, about 1 hour drive from Champai. So at the police station of Champai, they have received an information at around 6 a.m. And on reaching the spot, since they have detained one person suspected to be involved in the illicit drug trafficking, so they have received information and they rushed to the spot. And on discovery statement, even though there's no discovery statement annexed here, it was found that the illicit drugs, that is 70 kgs, 70.200 grams of methamphetamine was buried under the sand by the accused himself. Now, my learned friend have read out the only portion which he want to read out. First of all, what I'm saying is that there is no violation of the constitutional law. All formalities is complied with, in as much as there is nothing to indicate that he was taken from his residence at 2 a.m. in the morning. That is only his submission against the record available to us. And Your Lordship,
So
they
he
have...
was not taken from his residence.
Yes, no, as per the record available. If it all be, then they have to prove it before the learned trial court. And Your Lordship, they have annexed the acknowledgement letter written by the village council of the concerned residents of the having jurisdictions or the local residents of the petitioner, which is in page number 47, and the English translation is in page number 47A. That is the last page of the application. I could have understand the submission of my learned friend if it all be mentioned at least here. But what is mentioned here is that I hereby formally acknowledge and certify that Sri so-and-so, that is the application, is a bona fide resident of Dinthar. That's it.
This is accused.
This is the accused. We know that he's a bona fide resident of Dinthar because they have annexed the ID
Okay.
also.
So the,
No, nothing as such that he was taken from his residence, etc. No statement to that
so
effect is made.
This is probably the regarding confirmation that he was a resident of.
Yes,
Okay.
yes, just that.
Dinthar.
If at all,
Not arrested.
if at all, if there's any document which indicate that he was taken from his residence
Where is
at
the
2
arrest memo?
a.m.
Where is the arrest memo?
Arrest
you annexed-
memo is in page number... Cái lông gì? 19. Oh, 19. 19 of the application.
Yes. Champai.
Yes. Now, in paragraph number 3, occurrence of offense day Friday, 19/9/2025, time 6 a.m.
Place of occurrence.
Place of occurrence, day, Friday. Occurrence, day, date from so and so. And place of occurrence is
Page
5.
19.
Page 19. 19, Annexure 4. 6 a.m. to 7:30 a.m. Information received at PS. And place of occurrence in paragraph number 5 is near residence of Tel Tailawa.
6 a.m. Oh, just a minute. Occurrence day is Friday, date 19. 19 is same. And the time period. For 6 a.m.
So, Your Lordship, there's nothing which indicates that he was detained or taken from his residence at 2 a.m.
Okay.
But Your Lordship, presuming but not admitting that he was taken from his residence at 2 a.m. On 19th, still,
Just a minute. Where from you are submitting that he was taken from home at 2 a.m.?
it's just his submission.
Lordship, it is our submission which we
Just
have.
submission.
It's
Without,
your submission
without basing
only?
any record.
Your submission only?
Yes, Lordship.
Okay. But the record shows that it was at 6 a.m.
As per the FIR also, and all the records that is available for us for perusal.
These are also made on the same day,
Same date.
and then time is 7:30. Page 29.
Your Lordship, presuming but not admitting that he was really taken from his residence at 2 a.m. in the morning, but still, Your Lordship, I did not bring the citation, but with Your Lordship permission, I can give it later, just after this session, Your Lordship. In Mihir Raje's case, it crystallized as to how information, grounds of arrest, etc. has to be given. Now, it says that in Mihir Rajesh, it says that at least 2 hours before he was produced before the court. So it's all on time. So there is no violation of the constitutional law. I can provide the citation, Your Lordship, with Your Lordship permission. It's Mihir Rajesh case. It crystallized as to how the grounds of arrest has to be furnished to the accused. It's, yes, Mihir Rajesh versus State of Maharashtra in criminal appeal number 2195 of 2025, and judgment was delivered in the year 2025 only.
Citation?
I will give it later, Your
Okay,
Lordship.
okay, okay.
I didn't bring it here because I didn't think that
Okay.
it will not be required in as much as there is nothing in record to shows that there is violation of the constitutional law or the constitutional provisions. Now, Your Lordship, that is the appellant's words versus the records. Now, as already suggested and pointed out by Your Lordship, this is not a court of fact. The court of fact is the learned trial court. Now, if they are saying something which is beyond the record,
No, that
then they
cannot
have
be.
to approach the trial court.
See, page 30.
30, Your Lordship.
The name the accused is Lanun Thara.
Lalnuntara, yes.
So now we say that
Yes.
he is from my possession. He signed it.
And Your Lordship, that will be my next point.
The witness is his own father. Have you seen? The witness
Yes,
is his
yes,
own father.
on the left.
Lordship,
Yes.
it's true.
Your Lordship, second is that is my first point. Second is that, yes, it is written clearly that ceased from my possession and copy of Caesar memo is recorded. It's signed, duly signed. Even though this is yet to be proved before the learned trial court, what I want to submit is that there is
It's a prima
nothing
facie.
in the averments, in the application that says that he is not, this is not the language not known to him, or that he is reading in class 1, 2, 3, etc. So there is nothing to show that he do not understand what he is signing and that he is forced to sign this.
FSL report received?
Received, everything received. Charge sheet submitted only after
Okay.
FSL, etc.
What the report says?
It will be in the case record.
Okay.
The scanned copy of the case record is available, Your Lordship.
Okay.
So only once it is proved by the FSL that it's methamphetamine, then charge sheet is submitted. That is the procedure.
FSL report confirm that it's a contraband item?
Yes, Your Lordship.
Where do we find? Have you
In
seen?
local- in
Have you
the-
seen?
Yes,
Yes, yeah.
Your Lordship.
Okay.
In
Do you
the
have the
charge
copy?
sheet.
No.
I don't have the copy, only
You
the,
should have kept one copy.
we, I can have my junior go through that and point out while I make my submission, Your Lordship, if Your Lordship may permit.
Have you seen earlier?
Yes, I have
Okay.
seen in the last court date.
Just.
And that first submission is there is no violation of the constitutional provisions. There's no violation of the constitutional law, and that is the word of the accused against the available records. And second is that there is nothing in the application that says that he is illiterate or he is not educated or English is not a language known to him, etc. So as to now this has stopped him from saying that he do not understand what he was signing, and there is nothing on the averment that state that he was forced to sign. Now, Your Lordship, my learned friend have, that is point number 2. My ground number 3 is that my learned friend have said that, yes, they have to undergo the hurdle of the embargo of Section 37 of the NDNPS Act. Now, Section 37 of the NDNPS state that notice has to be issued to the PP so as to give objection, etc. And second, the second condition is that if there is reasonable ground to believe that he is not guilty of the offense. Now, Your Lordship, at this stage, how can we say that there is no reasonable ground to say that he is not guilty of the offense? Because investigation is conducted by the police personnel, and on founding prima facie case that he is guilty of the offense, then charge sheet was submitted. Now, trial is yet to commence. Now, at this stage, how can we say that there is no reasonable ground to say that he is not guilty of offense? If my learned friend can point out from the record, but they did not, it's just their submissions that there is no reasonable ground. Just simply saying that there's no reasonable ground would not suffice. In the case of NDNPS, in fact, this is the case wherein they have seized as much as 70.200 grams of methamphetamine. That is the third point. The fourth point is that, yes,
It's 70.200 kilograms.
70.200 kilograms.
200.
How much menace it would cost to the general public if that is in the market? how much life it would take. That would have to be taken into consideration, Your Lordship. And Your Lordship, on my fourth point is that, yes, reverse burden. My learned friend was concentrating on the reverse burden of proof, that is section 54 of the NDNPS Act. Now that comes only after, at the trial, at the stage wherein they have they have not proved the guilt of the accused beyond reasonable doubt. First, they have to prove, the prosecution have to prove the guilt of the petitioner beyond reasonable doubt, and then the reverse burden will come into play. But then now we are at the stage where the trial is yet to commence. But, Your Lordship, we need not indulge into section 54, that is reverse burden. But then section 35 of the NDNPS Act, there is presumption of culpable mental state. Now, in culpable mental state, what we can find from the record and based on the record is that it was only after his discovery statement that discovery was made. And coming to this, Your Lordship, if I may take Your Lordship kind attention to page number 22 of the application. My learned friend have already read out half of the part which he want to read out. But coming back to that, I will not read out the I will read from the middle, Your Lordship.
Yes.
I will start from during the search operation. It's in the middle line. Have Your Lordship have Your Lordship seen in total 656,500
Yes.
tablets? Okay, 3 lines above from that.
Okay.
With Your Lordship permission, may I read?
Yes, please.
During the search operation, we
Yes.
recovered and seized a total of 65 bundles suspected to be methamphetamine. Each of
Yes.
the 65 bundles contained 5 small bundles, and each small bundle consisted of so and so, so and so. The contraband was found concealed inside white nylon sack, buried under the sand by the accused named so and so. The estimated market value of the substance is 9.12 crores. The entire seizure process was documented digitally through eShaksha app. So in 2023, when BNSS has been made effective and in operation, now it is mandated that all the entire process has to be recorded in video. Now, this is not a court of fact. I must rephrase again.
Yes.
We do not have the app, but then from the record, we can see that the entire process
Yes.
from unearthing the illicit drugs is caught on the record. Now, that is against the words of the applicants. We cannot rely only on the word of the applicants. If they have something to say, they will have the defense witness evidence at that stage. They will have the opportunity to say that. But at this stage, what can we see is that information was received at 6 a.m. in the morning, and recovery was made at around 7:30 in the morning, and it was unearthed by the accused who have buried under the sand, and then the entire process was caught on eShaksha app. So there is nothing to show that so as to overcome the twin condition, to prove that he is not guilty of the offense. There is nothing to show on record, Your Lordship.
Any other persons like the Nothang Ranga from?
Yes,
Burfak
that is
Road
the
was also
father-in-law.
arrested?
That is the father-in-law of the.
Okay, father-in-law.
Father-in-law.
Of the
I have
accused.
gone through the yes.
Father-in-law of the accused.
Yes, I can show it from the case record, Your Lordship, that he's the father-in-law.
Okay, he sent the consignment.
Yes, he sent the consignment. The father-in-law sent the consignment.
And asked him to conceal it. Appropriate at some places. Okay, so the place, it was laid by him only, it appears. Is there any disclosure statement separately recorded?
Your Lordship, I will go through it.
Okay, what is that?
Yes. So,
Disclosure statement.
I will go through it. I'll
Okay,
see
okay,
whether
okay.
if it is there or not. Okay, report, no.
Because as per the FIR, it appears that he has disclosed it and led to the place.
Forensic picture. John. Suspect. Yeah. Your Lordship, we can have another look on your arm. Your Lordship, I have just folded it, the forensic report, and the next fold is the statement of the suspect, which we showed the relation between the co-accused.
Okay, give the flag. Okay.
The FSL report shows that the suspected seized article contains methamphetamine.
Okay, this is examination report, yes.
And the second fold is the statement of the suspect. I'm just going to, it's in vernacular language. My learned friend, if I can share it with my learned friend, if
Which
ju-
one?
ju- just to see whether my translation is correct or not, but then I will be.
Examination reports, discussions, examination analysis, and so positive. Okay.
So the next fold, Your Lordship, with your permission, I can share it with my.
Yes, sir.
Okay. It seems you have the copy. Statement of the suspect. This is J.H. Malin of 41. In the question and answer is there. In the question number 3, Nun tharanen hian eng tin nge in shat. It's written. Question number 3, it's Nun tharanen hian eng tin nge in shat. How do you and Nuntara came to know each other?
Okay.
And his answer is Ngo Tan Shang. Ngo Tan Shang is the co-accused. Is Nuntara's.
So this is in vernacular, not translated.
Yes, it's in
Trial,
vernacular language.
trial, just a minute, one. In the trial, whether the cross-examination or examination in chief are being done in Mizo, here.
In English mostly. In English
Mostly.
mostly. But then if they do not understand English, then it is done in language known to them.
Translated
Then
and
it's
recorded in
translated.
English.
Yes.
But then in any case, record is in English only.
English only.
Okay.
In most cases.
Okay.
But then usually before the police, it's done in the language known to them.
Okay. Okay. Anything else?
Lordship, I would like to make some additional
Just a
submissions.
minute. Let her come. Miss Mary, you done?
Yes, Your Lordship. So my humble submission is that, Your Lordship, at this stage,
Okay.
there is nothing to overcome the burden of the embargo of Section 37, so as to prove that the accused is not guilty of the offense that he is charged. And since this is not a court of fact, we cannot go into the investigation or inquiry as such to find out whether he was actually taken from his residence at 2 a.m. in the morning. But as I have already submitted before, presuming but not admitting that he was actually taken, I will give you the citation, Your Lordship. It says that so as to not violate the constitutional law, at least 2 hours prior to being produced before the court, they have to be furnished a grounds of arrest. Now, it is on the record that he was given a ground of arrest at 7:40 in the morning. So, Your Lordship, there is nothing.
Okay. What more? Yes.
Now, Lordship, as my learned friend has mentioned, Section 35 and 54, Lordship. Now, the statutory the presumptions under Section 35 and 54 arises only after the prosecution proves the conscious possession of the accused, Lordship. Now, here in our case, Lordship, there is no recovery from the petitioner, Lordship. The contraband was never recovered from his person, Lordship. There is no recovery
So,
from his.
It may not be recovery from his body, but then it was recovered from being
Yes.
led by him
Yes,
on his
Lordship.
disclosure statement given by the accused only.
No, Lordship,
It appears.
nothing was recovered from his residence either. No, Lordship, no packaging materials, no suspected contraband, no, nothing was recovered from his house. No, Lordship, there is no any recovery from his any vehicle, any dominion or control over his control, Lordship. Nothing was recovered from there. No, Lordship, also, as mentioned, the previous court date was on 6th of March, and the FIR was filed on 23rd of February 2026, Lordship. Yes. The charge sheet was filed on 23rd of February 2026.
Charge is filed on 23rd?
February 2026.
Hmm.
So now, Lordship,
Charge is filed against how many people?
the charge is filed only against the current petitioner, Lordship, the accused.
Against him only?
Only him, Lordship.
No any other person?
No any other, Lordship.
Okay, seizure item is includes where only the
Only this contraband
or
substance,
the
Lordship.
truck and other things?
Nothing,
not
nothing,
seized.
Lordship. Not even his cell phone, no nothing,
Okay.
nothing was seized.
Whether the person, the truck driver, the statement, a police statement of the truck driver and the father and then the father-in-law, who was the one?
Northern
who sent,
Shanga, Lordship, does,
Their
yes.
statement has been recorded?
No,
Have you seen?
Lordship, currently the main suspect, Northern Shanga, is actually absconding, Lordship. There is an
Okay,
arrest warrant
Who is
standing.
that?
He is the main accused, Lordship, as per the FIR which is mentioned.
Okay, he is absconding.
Yes, Lordship. And there is a arrest warrant in the charge sheet, Lordship, itself, which is
What is the name of the accused?
the name of the accused, Lal Nunthara, Lordship.
Who is J.H. Malena?
No, Lordship, J.H. Malena is,
He is also suspect.
yes, Lordship, a suspect, Lordship. So now,
He
Lordship,
was not arrested.
he was not arrested, Lordship. He was just mentioned as a suspect. Now, Lordship, I have here with me a translated
The
copy.
accused is Laltun Thara
Lal Nunthara, yes, Lordship.
or Lalun Thara?
Lal Nunthara, N-U-N.
Lalun Thara.
And the complainant is
Currently.
Lal Nunthara, Lordship. There is the police law, separate, Lordship.
Okay.
So, Lordship, since the charge sheet was filed on 23rd of February, so we had the liberty of gathering some certified copy, Lordship.
Okay.
No, Lordship.
Okay.
Also, additionally, what we would like to mention is that as per the statement of Malena, Lordship, I have here the English translation. If my learned friend can.
Who is Malena?
Yes.
What he stated?
Lordship, if I may go through. Statement. My names and particulars are stated above. Currently, I live at the lower floor of my parents' house in Zotlang with my wife and 7 children. Previously, I was a trader dealing in various items, including smuggling of Erica nuts, Lordship. I now own a mobile repairing shop at Khozol Vengthar to earn a living. Northern Shranga. Shranga is my cousin, my father's elder brother's son. Some time ago, Northern Shranga was in jail due to drug
This is
case.
accused.
No, this is not the accused, Lordship. He's mentioning
Another person.
the alleged supplier of the contraband, Lordship.
Okay.
Some time ago, Northern Shranga was in jail due to drug case. His wife borrowed rupees 60,000 from me to bail him out, which they have not repaid me till date. On September 18, 2025, Thursday, Northern Shranga called me. Since I was constructing my house, he had asked me whether or not I needed sand. Since he owned a lot of money, since he owed me a lot of money, I did not refuse. On September 19, 2025, the sand arrived by truck. It was sent around 9 p.m. He told me to place tarpaulin near my construction site in Zotlang. My brother-in-law, RTC Lalshiat Puya, and I went to the construction site to place the tarpaulin. He told me that Nunthara knows everything and will be handling it. So we left. The same night, Northern Shranga informed me that he had been caught. No, Lordship, as per the statement, Lordship, J.H. Malena, Lordship, he was very much aware of the sand which has been transported, Lordship, by the truck, which has been...
Malena was arrested.
He was arrested, but he is just used as a suspect, Lordship, in the charge sheet. He was neither a prosecution witness, but he just mentioned he was just given as a suspect, Lordship.
Okay, so he didn't know anything about, he had no idea about.
He had knowledge, Lordship, as per his statement, Lordship, here. He, in fact, contacted the main supplier of the contraband substance, which has been seized, Lordship. As per his statement, he knew he had contact with the main supplier, and it was mentioned here that the truck will be carrying the sand and will be delivered near his construction site, Lordship.
What is the name of the accused?
Lal Nunthara. L-A-L-N.
Lal Nunthara.
Yes, Lordship.
Whether this person, has he said anything about Lalu Nunthara?
Lordship, as my learned friend has mentioned and said earlier, in the third question, which is the English translation, if I may go through, Lordship. Ngothan Shranga is Nunthara's father figure. Since Nunthara's father passed away, whenever we went to Bulfexol, Nunthara used to stay at Ngothan Shranga's house. That is how I know him, Lordship.
So this Nunthara is the accused?
Is the accused, Lordship. Now, Lordship, one more thing is the Lordship. If you may go through the charge sheet, starting from the fourth paragraph, Lordship, on the charge sheet. From the charge sheet, the fourth paragraph, Lordship.
Charge sheet?
Yes. Page, Lordship, in the court.
Not in the petition?
Not in the petition, Lordship.
Okay.
Your Lordship, I have certain serious things that I need to mention. My learned friend here is saying that they have copy of the charge sheet when delivery of the documents is not yet commenced. If they have the certified copy, they can produce. But I think we will have to raise this issue with the special court.
Okay. What do you want to show from charge sheet?
From the charge sheet, Lordship, from the third paragraph, Lordship. It begins with interrogation of the accused person. The statement begins with interrogation of the accused person. On the charge sheet.
In a brief story?
On the brief story, yes, Lordship. Just the interrogation, just this paragraph will do, Lordship, if I may be allowed.
Okay, you can read just. Where am?
Interrogation of the accused persons.
Interrogation.
Yes.
This is. There is only one page.
No, Lordship, it's.
Okay, there is. Okay. This side. Okay. Yes, interrogation of the accused.
Interrogation of the accused person, Lalnun Kluanga, son of Dalrin Kluanga, of Dinthar Veng Champai, was done during investigation. The accused admitted his guilt, stating that on 18/9/2025, he, along with his friend Tuanga, a Tuanga of a resident of Dinthar Champai, went to Puilo village, Khozol district, to drop off and see off their mutual friend Lal Pansanga, also from Dinthar. Lal Pansanga intended to stay at Puilo to accompany his ailing wife, who is currently residing at her parental home in the said village due to ongoing postnatal medical treatment and recovery. At approximately 2 p.m. on the same day, he received a phone call from Northern Shranga, a resident of Bulfexol Champai district. He informed him that he intended to dispatch sand materials along with some contraband items in a truck. and that the consignment was to be delivered near the residence of one J.H. Malena, located at Zotlang near Champhai Bypass Road. He further informed him that the truck driver was unfamiliar with the destination and requested that he assisted directing the driver to the location. For the assistance, Nothan Changa offered to pay him rupees 5,000, which he accepted. Upon his return to Champhai later that evening, he went to a friend's house where he consumed liquor while awaiting further instructions from Nothan Changa. However, after some time had passed and no further communication was received, he attempted to contact Nothan Changa by phone but was unable to reach him. Assuming that the plan had been cancelled, he returned home and went to bed. At approximately 2 a.m. on 19th of September 2025, he contacted the driver of the truck. He called the driver and directed him to deliver the consignment near the residence of J.H. Malena at Zotlang Champhai Bypass Road, as previously instructed. Upon arrival of the truck, the said materials were unloaded, and during the unloading process, a concealed consignment hidden within the sand was discovered. Subsequently, he was formally arrested by the police along with seized consignment. Now, Lordship, as my learned friend had mentioned earlier, Lordship, we're not arguing on the merits of the facts of the case, Lordship, but we're always saying that, Lordship, there is this presumption that the accused is innocent, Lordship, and there is a reasonable doubt, Lordship.
Okay. Hard. Mr. Samuel L. Pachal, Learned Counsel for the petitioner. I've also had Miss Mary, Learned PP for the state. Okay, Wolfie.
Yes.
I'll pass for her.
Your Lordship, can I send the
Yes,
citation
yes.
with
Kindly
the
send.
proposed?
I'll be it. Okay, we'll finish the
Item number 9.
Much obliged.
May it please your lordship.
Yes.
We have filed IA for implement of the informant as respondent number 2 as per this honorable court order dated 6/3 of 2026. And my learned friend, the government, the respondent also have, we also have furnished a copy to the respondent, my lord.
Informant you have implemented.
Yes, my lord.
Okay. Copy.
Copy, I have received a copy, Your Lordship.
Hmm?
I have received a copy, Your Lordship.
You have received the copy, but the informant, have you taken steps upon the respondent number 2?
Your Lordship, notice is yet to be issued today.
Yet to be issued. Okay. Okay. Hard miss. Miss.
Zotan Sangimar.
Hmm?
Zotan Sangimar.
Which one? Third one. Jo Chuan Mai.
Zotan Sangimar.
Jo Chuan, which, this one?
Zotan Sangimar.
Okay. Learned Counsel for the petitioner. I've also heard Miss. There you have. Learned PP for the state staff. This is an application. This is an. Oh, this is a bail application file under section 483 BNSS 2023. Praying for release of the accused. This is an application of release of the accused on bail who has been arrested in connection with criminal trial SC number 124 2025 under section 10 arising out of Individual Women, AWPS, case number 58, 2025, under section 1 and 10/12 POCSO Act. Okay. Where is the impediment of the respondent number 2? Have you filed?
Yes, my lord.
Has it come on record? Impediment? Insertion of the name? Late afternoon. Okay, hasn't come along with this. Is it ready?
Yes, it's ready.
It's ready, then can be inserted here, or how do you do?
It should be inserted together with this application.
Okay. Next step, without issuing notice.
Your
Can a
Lordship-
notice be issued? I think
Your
notice can be issued.
Notice should be issued against the newly implemented.
Yes.
And after notice is issued in the same order, the applicant may be directed to correct the course title. So that's it.
Yes, so it hasn't come yet, but can we pass order? If it is ready, can you call?
Yes, yes.
Okay, that will be better. Okay, then in that case, issue notice. And whether the charge sheet filed?
Yes, my lord.
Charge sheet already filed.
Already filed. Your bail application earlier rejected? Have you filed bail application before the trial court earlier?
Yes, my lord.
How many times it was rejected?
One time only.
One time. Okay.
We are
When
at
it was
evidence stage
rejected?
right now.
When it was rejected? You have,
10th December 2025.
okay. December. Okay, that was before filing of charge sheet.
No, after filing of charge sheet.
After filing only. Now that means the trial is going on.
Yes, my lord. 17 March is the next court date for evidence of the victim, examination of the victim.
Or evidence of
Yes,
victim.
my lord. Victim.
17.
Yes, my lord.
That is necessary. Okay. After that only the status of the case also will be changed after recording of the evidence of the victim, isn't it?
Mm.
So we can fix after that only.
Yes.
Okay. Call for the trial court record.
Scanned copy.
Scan copy of the trial court record. Stop. After issue notice. Stop. The petitioner, since Mr. Mary, Nana PP, accepted. Nana PP accepted notice on behalf of the state. No formal notice need be issued. However, the petitioner shall take steps upon the respondent number 2. Stop. 2 by speed post as well as by usual process within 3 days from today. Stop. Para. The petitioner. Okay. Since the petitioner has how it is, it's by way of IA, the implement.
Yes, my lord.
Okay. Then that is to be disposed of, or it will be merged with this?
Can be disposed separately.
IA. Since it is ready, can we dispose of for the purpose of issuing notice?
Not in the process for today. So
Okay. Then
maybe
I think
Oh,
it will be
okay.
listed
IA
tomorrow.
is yet to be listed.
Then it will be listed tomorrow only.
Yes, my lord.
Okay. Only for the purpose of issuing notice only. Okay, then leave that one. Then issue notice also. Ms. So-and-so, Lana counsel for the petition, submits that she has filed impleadment petition. She has filed IA for impleading the informant in the case. Staff. However, the same is not listed today. List this matter tomorrow again along with the impleadment petition. Okay. We'll issue notice tomorrow only. Okay.
Yes.
Item number 10.
Yes,
My lord, I'm appearing for the respondent. This is the first time I appear. So
First time, okay.
I seek for some more time for submission of affidavit.
Okay.
Affidavit in opposition.
Miss?
Yes, Your Lordship, I'm appearing on behalf of my senior, Miss H. L. Masomi.
Okay.
She
Your
cannot
good
appear
name?
today. Malsom Klangi Roite.
Give the name, huh? Land Council. Appearing on behalf of Mr.
Miss H. L. Masomi.
Oh, Miss
H. L. Masomi.
Oh, item 10. No? H. Lal Malsawmi.
Yes, my
Land
lord.
Council for the appellant. Stop. Mr.
Raymond Labiak Zama.
Raymond Lalbiak Zama, Land Council, would appear on behalf of the respondent number.
Sole respondent.
Or sole respondent. Have you filed Wakalatnama?
Yes, I filed.
By filing Wakalatnama and prays for some time to prays for some time to file response. Stop. The prayer is allowed. List this matter after 2 weeks.
Yes.
Okay.
Item number 11.
Lordship, I'm appearing on behalf of the.
Response ipso advice, huh? Yes.
I'm appearing on behalf of the appellant, and in filing the instant RFA, unfortunately there is an unintentional delay.
This IA is for?
Lordship.
What is this IA for?
Condonation
Condonation
of
of delay.
delay.
Will issue notice?
Yeah.
Okay. Hard, Mr.
Larem Rota Chenkwal.
Hmm?
Larem Rota Chenkwal, Lordship.
Larem Rota Chenko.
Yes, Lordship.
Land Council for the applicant. This is an application. Filed under Section 5 of the Limitation Act 1963 for condonation of delay of 1,152 days in filing a connected appeal. For setting aside impugn ex parte judgment and order dated 14/12/2022 in civil suit number 30 of 2021 passed by the Learned Civil Judge, Senior Division, Aizawl District, Aizawl, Mizoram. Stop. Para issue notice by 4 weeks. The petitioner shall take steps upon the respondent by speak both with AD as well as by usual process within a week from today. Stop. List this matter after 4 weeks.
Worship.
Okay. Stand.